Municipality of Pililaya, Rizal VCA. Facts: the RDC rendered judgment in favor of petitioner Municipality of Pilila, Rizal, against private respondent Philippine Petroleum Corporation, ordering therein defendant to pay said plaintiff the amount of P5,301,385.00 representing the tax on business due from the defendant under Section 9 of Municipal Tax Ordinance No. 1 of said municipality for the period from 1979 to 1983. The SC affirmed the judgment with modification. Attorney Felix E. Mendiola filed a motion in behalf of plaintiff municipality with the RDC for the examination of defendant corporation's gross sales for the years 1976 to 1978 and 1984 to 1991 for the purpose of computing the tax on business imposed under the Local Tax Code, as amended. The corporation filed a manifestation to the effect that the mayor already received the sum as evidenced by the release and quit claim documents executed by said mayor. The court below issued an order denying plaintiff municipality's motion for examination and execution of judgment on the ground that the judgment in question had already been satisfied. When attorney Mendiola filed a petition for certiorari with the SC, PPC filed a motion questioning attorney Mendiola's authority to represent petitioner municipality. The CA dismissed the petition for having been filed by a private counsel in violation of law and jurisprudence, but without prejudice to the filing of a similar petition by the municipality of Pilila through the proper provincial or municipal legal officer. Issue 1. Attorney Mendiola has authority to file a petition in behalf of the municipality. Held no ratio, the Court of Appeals is correct in holding that attorney Mendiola has no authority to file a petition in behalf of and in the name of the municipality of Pilila. The matter of representation of a municipality by a private attorney has been settled in Ramos vs Court of Appeals (ETL) and reiterated in Province of Cebu vs Intermediate Appellate Court (ETL), where we ruled that private attorneys cannot represent a province or municipality in lawsuits. Under the above provision, complemented by Section 3, Republic Act No. 2264, the Local Autonomy Law, only the provincial fiscal and the municipal attorney can represent a province or municipality in their lawsuits. The provision is mandatory. The municipality's authority to employ a private lawyer is expressly limited only to situations where the provincial fiscal is disqualified to represent it. For the aforementioned exception to apply, the fact that the provincial fiscal was disqualified to handle the municipality's case must appear on record. In the instant case, there is nothing in the records to show that the provincial fiscal is disqualified to act as counsel for the municipality of Pilila on appeal. Hence the appearance of herein private counsel is without authority of law. The submission of attorney Mendiola that the exception is broad enough to include situations wherein the provincial fiscal refuses to handle the case cannot be sustained. The fiscal's refusal to represent the municipality is not a legal justification for employing the services of private counsel. Unlike a practicing lawyer who has the right to decline employment, a fiscal cannot refuse to perform his functions on grounds not provided for by law without violating his oath of office. Instead of engaging the services of a special attorney, the municipal council should request the Secretary of Justice to appoint an acting provincial fiscal in place of the provincial fiscal who has declined to handle and prosecute its case in court. Pursuant to Section 1679 of the Revised Administrative Code. It is also significant that the lack of authority of herein counsel, attorney Mendiola, was even raised by the municipality itself in its comment in opposition to said council's motion for execution of his lien, which was filed with the court a quo by the Office of the Provincial Prosecutor of Rizal in behalf of said municipality. The contention of attorney Mendiola that private respondent cannot raise for the first time on appeal his lack of authority to represent the municipality is untenable. The legality of his representation can be questioned at any stage of the proceedings. In the cases hereinbefore cited, The issue of lack of authority of private counsel to represent a municipality was only raised for the first time in the proceedings for the collection of attorney's fees for services rendered in the particular case. After the decision in that case had become final and executory and/or had been duly executed. Furthermore, even assuming that the representation of the municipality by attorney Mendiola was duly authorized, said authority is deemed to have been revoked by the municipality when the latter, through the municipal mayor and without said council's participation, entered into a compromise agreement with herein private respondent with regard to the execution of the judgment in its favor and thereafter filed personally with the court below 2 pleadings entitled and constitutive of a satisfaction of judgment and a release and quit claim. A client, by appearing personally and presenting a motion by himself, is considered to have impliedly dismissed his lawyer. Herein counsel cannot pretend to be authorized to continue representing the municipality since the latter is entitled to dispense with his services at any time. Both at common law and under Section 26, Rule 138 of the Rules of Court, a client may dismiss his lawyer at any time or at any stage of the proceedings. And there is nothing to prevent a litigant from appearing before the court to conduct his own litigation. The client has also an undoubted right to compromise a suit without the intervention of his lawyer. 22. Even the lawyers' right to fees from their clients may not be invoked by the lawyers themselves as a ground for disapproving or holding in abeyance the approval of a compromise agreement. The lawyers concerned can enforce their rights in the proper court in an appropriate proceeding in accordance with the rules of court, but said rights may not be used to prevent the approval of the compromise agreement. The apprehension of herein counsel that it is impossible that the municipality will file a similar petition, considering that the mayor who controls its legislative body will not take the initiative, is not only conjectural but without factual basis. Contrary to his pretensions, there is presently a manifestation and motion pending with the trial court filed by the aforesaid municipal mayor for the withdrawal of the satisfaction of judgment and the release and quit claim 24 previously filed in the case therein as earlier mentioned.